Oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 25-1710. Inova Healthcare Services for Inova Fairfax Hospital and its Department Life with Cancer et al. Versus Omni Shoreham Corporation appellant. Mr. Lemke for the appellant, Mr. Mahoney for the appellate.
Morning, counsel. And Judge Randolph is joining us by audio, just so you know.
Good morning, and may it please the court. The district court's initial ruling on summary judgment was a quintessential and correct application of the summary judgment standard, and the district court spelled out in great detail why there were genuine issues of material fact that compelled a trial and a decision by the jury. Then, in a head-scratching 180, without any additional evidence being submitted or new law being cited, the district court reversed himself and issued a quintessential order which shows a district court crossing the line and making credibility determinations and weighing evidence in a way that invaded the province of the jury. The judge got it right the first time when he said there were genuine issues of material fact. And let me deal on three different issues. The first of them is the materiality of the contract, of the breach of contract. And the DC Court of Appeals in the 3511 13th Street case has said that is a quintessential fact issue. And it is. The courts applying DC law look to the 5 restatement factors to determine materiality of the breach. And I think the error the judge made is highlighted by a statement made in page 31 of the appellee's brief, where the appellee notes they win because there's no evidence at all to support any of the restatement factors. And I think that's an implicit concession by the appellees that if there is any evidence to support any of those factors.
Well, not any evidence. It has to be evidence on which a reasonable jury could rely. In the face of all of the other evidence.
True, okay. Your Honor. True, Your Honor. But I don't think a fair reading of this record, anyone could conclude that there was not sufficient evidence on those factors, at least 3 of them, to submit the issue to the jury for a decision. And for example, the first factor is the extent to which the injured party will be deprived of a benefit which it reasonably expected. Well, the reasonable expectations of the parties is an issue in which there was conflicting evidence in the record, and the jury needed to make that determination. On the question of whether the conduct or the breach was consistent with good faith and fair dealing, again, there was evidence in the record disputed, which needed to be resolved by the jury.
Well, it seems like your client knew exactly what they wanted. They had contracted for these rooms. They contracted for these same rooms, ballrooms, for a few years. They had negotiated to take out the authority of the hotel to switch rooms. That was removed, and Omni agreed to removing that authority. And then Omni intentionally, knowingly, deliberately chose to give those rooms to someone who was paying more and shuffle this gala off to rooms that there's substantial evidence in the record were too small, too low. You were going to put them partially in a tent. They were going to have a restaurant, which there was evidence in the record was not going to be feasible for their silent auction. Low ceilings, the video equipment wouldn't work, cables would be running everywhere. And I don't see anywhere where Omni rebutted any of that. All you got is somebody who throws out a bunch of adjectives about how wonderful, great, tremendous this other option would be. Where did you rebut in the record?
Your Honor, I think
there were obstructed views in the Blue Room. It couldn't accommodate the stage setup, too small to allow volunteers to navigate the room. Having to use a tent exposes people to temperatures, weather conditions, and isn't glamorous in the way ballrooms are. What evidence in the record did Omni show to counter that evidence?
Well, Your Honor, there was evidence in the record that you're certainly right that there was evidence submitted by Inova in support of.
Where's your evidence that it didn't have obstructed views? The stage setup would work. It wasn't too small to have a feasible silent auction. People could navigate the room without tripping over cable cords. What evidence did Omni put in?
Your Honor, we had evidence that the rooms would work.
That's a conclusion. That's not evidence.
Well, Your Honor,
I told you there's a bunch of adjectives. Oh, it'll be wonderful, beautiful. We think it's better. That's not factual evidence that it will work, countering this evidence that it didn't work.
Joint Appendix 262 at paragraph 39, Joint Appendix 263.
What did they tell me? Tell me how they show that the ceilings aren't too low, the room's not too small, that there's a stage set up that'll work.
Your Honor, at paragraph 39 at Joint Appendix 262, it cited extensive evidence in the record that the space was adequate based upon expected attendance.
Wait, that's just a conclusion. I'm asking you what facts? They came forward with facts as to why this wouldn't work. Where did you counter the facts to show it would work? Just a conclusion. When someone says, here's 7 reasons why it won't work, right? If we were having an argument with 10 parties on each side and people in the audience of 200 people, this room wouldn't work. This is a great courtroom. It works for today, but it doesn't work for every situation. So where do they say, where's the factual evidence countering? Not conclusions. We think it's great. We think it's fine. We think it'll work. Where's the facts?
Well, Your Honor, at paragraph 51 on Joint Appendix 263, there's citations to as to the seating capacity of the room being.
That wasn't their complaint.
That was one of the complaints they made.
Well, that's not one of the ones I just gave to you.
Well, Your Honor,
Where does it show that they'd be able to set up the audio visual displays that they've done every year?
Your Honor.
Is there anything, maybe it's just a yes or no question. Is there evidence showing that they would be able to do it?
I don't think there's specific evidence on that point, but the people who manage the catering and banquet facilities at the hotel talked about the needs of this event and said this room would be adequate. And
I just listed you the needs and you can't, and again, I get that you have people saying it'll be adequate, someone saying it'll be great. Those are adjectives. Those are not evidence. Where's the evidence?
Well, respectfully, Your Honor, I
You
think.
said there was evidence, a factual dispute about materiality.
Well, with respect, I think.
There's facts.
I think that is evidence when you have the people who run the facilities at the hotel saying this will work fine for this event.
Well, that is not. When someone comes in and says, no, here's what I need with detailed specificity, and you stand there and your folks stand there and go, oh.
Well,
is there an affidavit where someone explained how the audio visual would work in this environment?
I don't believe that's in the record, Your Honor.
Is there evidence from the record from somebody on the staff saying, oh, the silent auction will be able to work here. You'll have enough space for people to circulate and you'll have the same type of flow that you had between the 2 ballrooms?
Well, there was certainly evidence from the people who said the flow would work. But
no, people can flow is not the same thing as people will flow in the way you need to have them flow for a silent auction between rooms and move around easily. Navigating around a restaurant area isn't going to work.
Well, Your Honor, I think ultimately that is
you got to have, I don't think a reasonable jury, because someone from catering gets on the stand and says, we think it will work. And then you come in with all the type of evidence that Inova had here and show detailed reasons, one after another, logistical reasons why it won't work. It wouldn't be reasonable for a jury to reject that concrete evidence in favor of someone just going, I think it'll work, but it's not my event.
Well, on that point, Your Honor, I disagree because I think that's weighing the evidence. And it may be that a jury would weigh the more detailed, specific evidence more heavily, but it doesn't mean that the district court should have not allowed them.
The best case that a conclusion, we think it will work, counts as evidence.
Your Honor, I'm not sure I can cite you a case that detailed.
That's the legal conclusion for the jury to make, is whether it would be sufficient or not. That was the question you wanted to submit to a jury. But someone telling a jury, we think it's fine.
But Your Honor, I think it went beyond just a mere, it will be adequate. They talked about it had handled significant, elegant events in the past with,
That's irrelevant. This courtroom handles arguments every day, almost every day, and they work perfectly for these cases and an audience of this size. But they don't work for other situations. We had on bank arguments on Tuesday in a different, larger courtroom because that's what that event needed. So the fact that it worked great for other events is not at all responsive. It's not even contrary evidence that creates a genuine dispute of material fact as to whether it was going to work for this event.
well, Your Honor,
It seems to me like you don't have evidence on countering theirs on materiality, right? And the evidence is crystal clear that it was an intentional and deliberate breach of the contract. So I'm trying to figure out what, you can go through more materiality factors if you want, but I'm trying to figure out.
well, Your Honor, I think one of the factors goes to the implied duty, well, the duty of good faith and fair dealing.
Yeah, right, good faith when you've intentionally done it because someone offered you more money. This was a repeat customer who'd come year after year after year.
Well, I understand that, Your Honor, but
He was offering more money.
the issue here is that, the question is, there was evidence in the record of good faith in the form of they were moving it with enhancements to another.
Okay, so just to be clear, when someone has negotiated out of the contract and your client agreed, has negotiated out the ability of the hotel to move rooms. And despite that negotiation, which had been there for years in contract after contract, you do it. You don't ask for their consent or permission. You go, it's this way or the highway. Is that your idea of good faith?
Your Honor, there was evidence in the record that supported a jury's conclusion that it was consistent with good faith and fair dealing.
No, it was not. There was that you put in evidence that there's a generic practice of hotels doing this. You put in zero evidence, unless you can point me to something that said after a client has negotiated to not have that option allowed in the contract, you did it anyhow without their consent. Show me where you had evidence that it's common industry practice after it's been negotiated out of the contract and without even their consent or even consulting with them on the change. What evidence was there of that? A generic circumstance that absent that contract negotiation, this happens is irrelevant in this situation. It's just not responsive to the contract at issue and the negotiations at issue.
Your Honor, even the district court conceded in its reconsideration opinion that construing the evidence in the light most favorable to Omni meant that there was evidence to support the idea that there was an industry practice of moving this in a circumstance without consent. Now, the district court.
But that's not responsive to a contract where they negotiated that term out of the contract.
But Your Honor, I think.
Is that right? Was there any evidence like that? Was there an industry practice that notwithstanding express negotiations to remove that option from Omni, hotels still do this without consent of the other party? Is there any evidence in the record about that?
Your Honor, not to that specific degree.
That's the issue in this case.
Your Honor, I respectfully disagree because I think it is up to the jury to decide. When you couple the evidence of Omni believed the other rooms would make it a better event, including with the enhancements they were going to include.
Better is just an adjective.
Well, but they talked about, Your Honor, that they would have a higher level menu and they would do the tented patio.
It's not, well, one, who wants a tent when you could have had ballrooms? And they had evidence about the concerns about tent. Well, no response to that. And they put in, again, concrete evidence. This is not going to work for audio visuals. It's not going to work for our flow. And you're just going, we think it's better. We're going to give you enhancement. We're going to buy a table. We'll give you this other menu. If it was such a great trade, you wouldn't need enhancements, would you? If it was such a great trade, such a great location, you wouldn't need to offer enhancements.
Your Honor, I think the evidence was, and it's in the record, that because they were a good customer and they were making the move, they were offering these enhancements.
They were making the move. You were forcing them to make the move.
Well, that's correct, Your Honor. But because that consistent with what a reasonable jury could conclude is the industry practice that you can move a party without consent, which is in the record, that there was evidence in the record that
contract negotiations, and that's the issue in the case. I mean, having a dispute of fact that is not relevant to the issue before the court doesn't get you out of summary judgment.
Well, Your Honor,
We could have 20 witnesses say this courtroom is terrific. It's industry practice in federal courts of appeals to have a courtroom of this size for ordinary 3-member arguments on a panel. You could have endless people saying that. But it would be irrelevant if we're having different cases.
Your Honor, I think, well, our position is obviously that there was sufficient evidence in the record, even though the district court and this court may believe it was heavily weighted toward the plaintiffs. There was evidence that the jury should have considered. But with my remaining time, let me turn to the second issue, which is the district court ruling erroneously as a matter of DC law that Omni could not present evidence of failure to mitigate because DC law, never, according to the district court, never required a party to continue dealing with the breaching party. Well, that is not DC law. The Sizer case makes clear that's not DC law, and thus the district court made a plain error of law in precluding Omni from putting forward the mitigation evidence. And even if you believe there was a breach, then they turn to the issue.
Your mitigation evidence focused simply on this whole exchange that Judge Millett had about what you could provide in terms of a different room?
Yes, Your Honor. But there's a difference. Even if you accept Judge Millett's view that for the question of breach, that we didn't have enough evidence to say that it, to counter, with which I disagree, but I accept.
And before you answered the question I just posed, just getting back to the framing of the contract, you're offering specifically unique rooms within that hotel. That's what you're selling, correct?
Well, Your Honor, there are certainly.
You're asking the client who goes around and has this demonstration and walks through with whoever your hotel manager is to select their room, that you're selling specific space based on needs of that particular client with respect to their event. That's what you're selling. And then you might have a clause in a lot of these contracts that says it's kind of up to you all as the hotel manager, that from time to time industry practices will allow you to switch your room. But the real problem here too is that you're making an opinionated judgment about what the client's needs are, as opposed to doing what Judge Millett is saying. Here are the client's specifications, and you're only telling us, we think that that is sufficient to move it over here.
And Your Honor, that may well go to the question of whether there was a breach, which we have not challenged on appeal. But materiality, if you look at the first restatement factor, doesn't talk about whether you're going to be deprived of a term. It talks about whether the injured party will be deprived of the benefit that was reasonably expected.
But the benefit is being in that unique character room that has a particular setup that works for this particular event. That's the benefit.
And Your Honor, I think if you look at the evidence, a reasonable jury could conclude that the benefit here was having space that was the proper feel and flow. Those were Mr. Hisaoka's words in his affidavit.
But it goes back to what you were selling, because to me, the way you're presenting this case, it's a bait and switch. It's the day after, if some lucrative contract comes in, immediately the contract's over in your terms.
Your Honor, let me offer this hypothetical. If the Omni had had a mirror image complex of ballrooms on the other side of the hotel,
But they didn't here, but go ahead.
But they didn't. But if they did, would anyone seriously say it would be a material breach to move them, even if they had expressly said, we want ambassador and regency?
I think that's a different hypothetical than what's going on here, though.
I actually think it's for the jury to decide. I don't think it is, because
I don't know that they would be here or having the situation, if that's all it was move across the hall.
But
Assuming that you still had the nice windows and the ocean view or whatever else that they wanted.
my point, Your Honor, is if you accept my hypothetical that if you had identical ballrooms or closely identical ballrooms, it may not be a material breach, then it's clearly a jury question.
No, because you weren't offering identical
Right.
ballrooms. But anyhow, you'd still have the problem that they negotiated out of the contract your power to make that switch without their consent.
And Your Honor, that's why we're not here.
What if it turned out that the reason they wanted these rooms, this was a benefit, it came out of his sister, Joan Hisakawa's death or cancer treatments and death. If that was her favorite room, it'd been her favorite ballroom, that was a special place to them. That's why they negotiated the way they did. They entered into a contract with you. We need these rooms. We always have these rooms. I'm not sure the answer is that you could just switch them out without their consent.
And Your Honor, well, and of course, the jury would have to decide that because there was evidence that that is the industry practice. But I think a lot of what you're talking about goes to the question of
If we were to go on the website and look at these two rooms, the room you offered as the backup plan, is it the blue room? The blue room.
The blue room and the
you look at
Roberts
the
Restaurant and the
ballroom,
terrace.
And if you were to look at the ballrooms, does a blue room look like a ballroom?
Your Honor, it does.
It
I was
looks
there.
like a
I looked at
ballroom.
it last night.
It has a chandelier. It has high ceilings. Is that right?
It certainly.
Does it have high ceilings?
Not as high as the Ambassador or the Regency, but it
Right?
has
Does it
high
have a
ceilings.
Chandelier? How high compared to the ballrooms?
Your Honor, I'd
Is
say,
it, no, I've come to high ceilings.
my guess is it's 6 feet higher in the Ambassador Ballroom
no
would be my
chandelier?
guesstimate.
Chandelier,
Boy, Your Honor.
space-wise?
You're testing my memory. I mean, it's not as large a room. That's because it seats 580, I think, as opposed to 1,500, although they were expecting 400 here.
You could have told them that when they first were signing up, but you didn't.
But Your Honor, to the point you make, might someone look at the combination of the Roberts Restaurant, the patio, and the blue room and say, this is better? Yes. Yes,
Okay,
they might.
all right.
Okay, well, quickly back to mitigation then.
Yes, Your Honor. Thank you. The district judge ruled as a matter of law that in DC, you can never be forced to mitigate by continuing to deal with the breaching party. That is wrong. That is flat wrong. And he prevented us from putting on mitigation. And even if you accept the view that Judge Millett has been putting forward, and you, Your Honor, that, well, it was a material breach. That's a different question than from mitigation, because once you establish that there's been a breach and it's material, then you turn to damages. And we pleaded the affirmative defense of failure to mitigate. And we had a right to put on our evidence, and the district judge prevented us based upon his view that you could never be required to continue to deal with the breaching party.
So you're asking for a remand, a reversal, and then a remand on just the mitigation issue?
At a minimum, a new trial on the mitigation issue.
Okay, and then what about the standing issue, third-party beneficiary?
Your Honor, that is one where the district court erred in saying there was no genuine issue of material fact on that, because the question was, the easiest way to prove an intended third-party beneficiary is to put it in the contract. They did not put it in the contract.
But there was a practice of this particular third party sending in information, the tax forms, the payment, et cetera.
And that's evidence. And
Okay.
the district court, but there was countervailing evidence. They were never mentioned in any of the correspondence. The 30B6 representative of Omni said, we didn't know they were,
You just accepted a check from somebody.
That's right. And so ultimately.
That was a continued acceptance of a check.
That's right. And no doubt in a jury trial, they would argue all of that, but we would argue our evidence.
You would argue that you didn't know that the same entity was giving you the check?
As we explain in our brief, Your Honor, there's a difference between receiving the check and what DC requires is that both parties intended this entity to be an intended third-party beneficiary. And you can be an incidental beneficiary and not have the ability to enforce the contract. And we had evidence on standing, and the district court, what's remarkable about this situation is the plaintiffs never moved for summary judgment on standing. Omni moved for summary judgment, and the district court concluded in its first opinion there was a reasonable jury could conclude that there was standing, and so and thus we didn't win as a matter of law. But that's a big difference from saying a reasonable jury had to conclude. And so we think that they did not, that he erroneously entered summary judgment effectively on the standing issue. And so you would have to go back for a full, that issue would have to be taken up in any retrial.
Can I ask you, if you were to prevail on this third-party beneficiary argument, that it wasn't summary judgment, appropriate for summary judgment, obviously not to grant summary judgment, but it would need to go to a jury. Would you have to have a new, and assume for purposes of the question that you don't prevail on the other arguments. You might, but assume for purposes of this question, you don't. Do you have to have a whole new damages trial? The jury already broke out different damages percentiles for Inova and Smith.
Are you saying, Your Honor, in your hypothetical, you would rule against me on the judge not allowing us to put on failure to mitigate evidence?
I'm saying for purposes of this question, because I'm
Okay.
trying to understand this jury verdict here and what it means, because it divided up some damages, and then there was another thing called costs that was not divided up. And so
my view, Your Honor, is it would need to go back on your hypothetical.
yes, I'm sure you want it back for a whole trial.
I want it back for a whole trial, or at a minimum a new damages trial.
Right.
But assuming we're not going back at all on Inova and only on Smith Center, I think there would need to be a new trial on the standing issue. And if there was standing, what are the damages?
Well, if you're going back for a new trial, it's already been determined that it shouldn't have been done summary judgment on the third party beneficiary status. That's why you wouldn't be having a new trial unless we decide that summary judgment was wrongly granted.
Right.
So you don't go back for, yes, you go back.
And I believe.
Why do you need, I guess what I'm trying to ask you is, if it turned out, the best that could happen for you is a whole removal of all of Smith's money award, right?
Correct.
Now, this is why I'm asking the question. So the damages is first broken out separately between Inova and Smith. You wouldn't need a trial on that. You would just take out Smith's share of that. Now, the other side may want to do the trial, and then you wouldn't. But if I'm just trying to sort of figure out how this works. If do you just take that out and do you divvy up the costs, or do you have to have a whole trial on the costs issue alone? It doesn't seem you would need, unless the other side insists, a trial on the already divided damages.
Well, the jury put it in three buckets.
That's what I'm asking. I'm asking, what do you do with bucket 3? What happens to bucket 3?
And is bucket 3 the Inova or the Smith only damages?
No, that's the exact same buckets that are on the verdict form. It's a third bucket, which is the costs one, the $37,000 one, right? What they would have received had the breach not occurred is already broken out between the two of them.
But my
So
view,
that's already determined by a jury.
right.
What about
The
$37,000 in costs?
I think you would need to have a new trial, at least as to Smith Center, as to whether the jury awarded that amount as to them.
So you have a whole trial over beneficiary status and $37,000, how to divide up $37,000. That's.
Well, I mean, my view would be, one would think this jury would need to hear all of the damages evidence on Smith Center, since.
Not all of it. It's already been divided by a jury.
Well, but is it, did
You haven't challenged the jury's award as to its amount
Well, that's correct, Your Honor,
or
but
its division between Inova and Smith. So you don't have any complaint about that, assuming you're not having a trial on everything. Obviously, that would take care of all this issue. You haven't complained about that. And so if the third party beneficiary issue needs to be resolved by a jury, and if they find in your favor of no third-party beneficiary status. It seems to me the only main issue is what do we do with this $37,000 or the category of additional costs?
I mean, it certainly is an unusual situation, Judge, where the jury that is deciding whether there's third-party beneficiary status would not also, it would have all been decided together, the damages too. But at a minimum, at the new trial, you would have to have the third-party beneficiary status and the common bucket, the third bucket, as you put it, at a minimum.
But to be clear, you're saying what would go back before a jury is the third-party beneficiary status and then mitigation of the?
Well, Your Honor, I mean, as Judge Millett alluded to, we think it should go back for a new trial on every liability and if they, but you know, that's our first argument, the materiality. But if you don't agree with us on that, then we think it needs to go back for a new trial where we are allowed to put on our failure to mitigate damages because we have challenged the jury award based upon they didn't get to hear our failure to mitigate damages, which was a legal error by the court. So that would be a new trial on damages with
On everything, all the damages.
all the damages.
Yes.
So
But-
damages, mitigating and third-party beneficiary status.
Correct.
Okay, just,
But if the
Those
only
two.
issue is third-party
If
beneficiary.
the only issue is third-party beneficiary
just that
status,
Third bucket. I mean, it's already been divided otherwise. and You haven't challenged that.
you know, well, we challenged it because of the mitigation evidence not
But
being heard.
but I'm just, again, this is just hypothetical, right? There's.
I mean, it strikes me, Your
just
Honor.
trying to Figure out just, you know.
It strikes me as an unusual, it strikes me as a very unusual situation where the jury that is deciding third-party beneficiary in bucket 3 was not also deciding the Smith Center only damages bucket 1.
You know, it happens if there's trials and there's just a discrete issue on which, I'm not saying this is what would happen, to be clear. I'm just trying to think through different outcomes here to make sure we're testing everything with both counsel here. Where you have a summary judgment, then it gets overturned on a singular issue and you go back and you do a trial on that singular issue and whatever undisputed or still disputed damages on that.
but I want to be clear that if you have the jury verdict indicating what's owed by Omni, you're leaving that intact. You're just trying to mitigate against that number. You're not saying start over on damages.
I think you would have to start over on damages, Your Honor, because they might not award, for example, the 60,000 to Smith Center. They might award 0. I mean, they're going to have to
You
come up.
haven't challenged
And that's what I'm getting
that
at.
part of the judgment. You just haven't challenged that jury verdict, which is a wise strategic choice. It's virtually impossible to do.
Well, Your
Why would
Honor,
we redo that?
well, we
Why would
challenge
we
it.
waste court?
No.
Again, assuming, for my hypothetical, assuming,
Right.
I think we both, all three of us thoroughly understand that you want a whole new trial on everything. I mean, at this point, your attorney's fees are going to have to be 10 times whatever the damages were actually in this case. But you want to go back and do this and have, you know, Omni's behavior in this case advertised all over a courtroom and before jurors in the district again. That's your choice.
But Your Honor, I want to make clear that we're all on the same page because your hypothetical where it would be only the third-party beneficiary in bucket 3 was based on the assumption that the failure to mitigate is not going back.
That's my question. That was just a hypothetical question. Yes.
Okay, yes. And so,
I agree with you that if that mitigation goes back, then all damages go back. And if you win on your materiality claim, then everything goes back.
and that's the point I wanted to clarify for Judge Childs, that if the mitigation goes back, then the damages goes back in its entirety for a new trial on that.
Okay.
Any more questions?
No.
Okay, thank you.
Thank you, Your
Give me
Honor.
A couple of minutes for rebuttal.
Okay.
Morning, and may it please the court.
Morning.
On the mitigation of damages issue, the district court did not arrogate jury's role in deciding whether Inova fulfilled its duty. Instead, it appropriately determined which facts the jury could consider. That's a legal question for the court. In addressing that legal question, the court was not presented with any authority by Omni requiring an injured party to mitigate by renegotiating the contract after the breach.
But it's up to the court to determine what the law is, regardless of what the parties submit to it.
Yes.
So what would you say about the Sizer case and the ability to actually mitigate?
Right. And Omni never argued before Judge Bates that Sizer required Inova to mitigate by renegotiating the contract.
But that's not my question.
Yes.
The question is, what is the law?
Right.
Because that's for us to determine and get the law right to the jury.
Sizer merely concluded that in appropriate circumstances, the injured party may continue to perform a contract if that puts him in exactly the same position. That's not what happened here. Omni did not offer to continue to perform the contract and provide Inova with exactly the same benefit after its breach. Given the absence of any DC authority on that question, the district court appropriately looked to decisions in other jurisdictions, which make clear that Inova had no duty to renegotiate the contract after it was materially breached. That would turn contract law on its head and constitute an unreasonable overreach of mitigation principles by rewarding the breacher. Under the Restatement Second, Section 350, which the court cited, whether alternative transactions are a substitute, an adequate substitute, depends on the similarity of the performance and the places where it would be rendered. Omni reassigned the gala to radically dissimilar space.
So you're saying that in Judge Millett's earlier hypothetical, or actually your friend on the other side, if it was a room across the hall that was identical, then this might be a different case about mitigation.
It might be different, but
Okay.
that's not our case. An injured party, as a matter of law, as this court held in Kamler and Buckley Madison, is at liberty to reject an alternative that's dissimilar to the original. Omni was at liberty to reject the dissimilar alternative proffered by, Inova was at liberty, proffered by Omni, and as a matter of law, was not obligated to host the gala in those fundamentally dissimilar alternative spaces. So Inova, as a matter of law, acted reasonably by refusing Omni's post-breach offer. Omni, as a matter of law, the party who forced the choice, may not argue that Inova should have accepted Omni's offer of alternative space over moving the gala to an alternative venue just because Omni thought that was more advantageous to Omni. Now, whether Inova fulfilled its duty to mitigate by seeking an alternative venue elsewhere instead of rescheduling the gala was an issue properly left for the jury, and the jury decided that. But as a matter of law, the court was correct in determining that Omni could not maintain at trial that Inova should have accepted the alternative spaces that constituted the very breach that was at issue.
Well, I thought your point was not that it just constituted the very breach, but that they were dissimilar or inferior.
It's both, yes.
Okay. And then I think you need to say them together, because I thought you just agreed that if they were the very, breach that they were offering was rooms right across the hall that were mirror images of the other, it'd be fine. So I think it can't just be that you could reject because it's different and it's what they're offering.
Right. It's a material breach in part because it's dissimilar.
Right.
And it is contrary to the reasonable expectation of Inova over the years to use that same room that the parties had negotiated to delete the reassignment provision in the contract to. So this was something that occurred from 2013 to 2019. That was the essence of the contract. That's why it was entered into by Inova. As for standing, Omni's request that it be given a jury trial on Smith Center standing rings hollow. Omni had that opportunity in the earlier jury trial, but never put standing at issue, and standing was never controverted. That's because there was really no genuine issue of material fact.
What are you talking? I'm very confused. They weren't allowed.
No, we're talking about standing, Smith Center standing.
Okay, so third-party beneficiary
Yes,
status, which actually
yes.
is not standing anymore. The Supreme Court cleared this up some years ago.
Well, it's Omni's argument that Smith Center lacks prudential standing
Yes.
because it's not a third-party beneficiary.
well-
They had the opportunity to litigate that at trial.
The damages trial?
Yes. Or to raise the issue pre-trial.
They had already raised that the district court had granted summary judgment in your favor on that issue.
No, Judge Bates actually, in his opinion, post-trial opinion, made the appropriate remark that the issue of Smith Center standing was not controverted at trial because it was decided on summary judgment by Judge Bates. Omni never disagreed with that. They didn't.
Of course they disagreed. They opposed summary judgment.
No, they never raised the issue of standing.
After summary judgment is granted to Inova, they were still supposed to ask to prove that at a damages trial?
At a minimum, they should have raised it if they thought it was controverted. In fact, when they filed
Of course they thought it was controverted. They opposed summary judgment.
well, but when they filed their post-trial brief asking for a new trial, they basically argued that the court should have resolved standing at trial. Our response was, no, it wasn't controverted. You didn't raise it because it had been adjudicated on summary
That is an
judgment.
attack on the district court. To say that something has to be adjudicated at trial is to say the district court erred in granting summary judgment.
Well, my point is it was never raised at trial. So,
Of course not.
yeah.
I think a district court would be very mad if they entered such a summary judgment on something, you lose. And then when someone said, okay, I've lost, but gee, I sure would like to try this before the jury on damages.
Well, the point is they never raised it pretrial. And
When
that,
did they have to, of course they raised it pretrial. That's when summary judgment is pretrial.
Judge Bates made the comment that they should have raised it pretrial if they thought it was controverted. They didn't. And that's just another indication.
Summary judgment pretrial?
Summary judgment was pretrial.
Did they raise there that they didn't think that they opposed summary judgment on third-party beneficiary status?
They did, yes.
So it was controverted pretrial.
It was. But it was controverted.
They were supposed to keep raising it.
Well, that's the remark Judge Bates made.
Wait, you can tell me he made that remark. Can you tell me any federal rule or case decision that says having lost summary judgment, you may not challenge that legal ruling unless you object again on an entirely different issue called a trial on damages?
Well, it's Omni's point, or it's their position, that the summary judgment wasn't adjudicated.
Okay, so do you have that it was not properly adjudicated at summary judgment? That's their position. It was improperly resolved at summary judgment. Do you have, I'm going to ask again, a single case that says they had to raise it again at a trial that was limited to damages?
Well, the court has to ensure that it is subject matter jurisdiction at all.
It's not third prudential standing is not subject matter jurisdiction. Third-party beneficiary status is not subject matter jurisdiction. Supreme Court said in Lexmark, we're not doing this prudential standing thing. It just goes to failure to state a claim. That's not jurisdictional either. There is nothing about subject matter jurisdiction here. Smith Center, I assume you would agree, had Article 3 standing. They were injured. They lost money. Jurisdiction's established. That's it. So there's nothing more to be done.
Well, it's our position, Your Honor, that there was no genuine issue of material fact on Smith Center standing. And the fact that it wasn't raised by Omni before trial is an indication of that. None of the three types of evidence identified by Omni is sufficient to disturb that undisputed fact. Third party need not be named in a contract if the surrounding circumstances tend to identify it as a beneficiary.
What surrounding circumstances are you relying on that would have required a reasonable jury to find that they were a third-party beneficiary? Not that they could have,
Right.
but would have required them to do it.
Right. So Omni's position is that they had no knowledge of Smith Center. That's clearly not the case. The record is overwhelming that over the years, Smith Center paid hundreds of thousands of dollars.
Knowledge of the existence of Smith Center, knowledge that Smith Center is funding or helping to fund a gala is not showing knowledge that they were a party to this contract. Is it?
A third party can be implied.
It can be implied, but again,
Right.
you just said that they were writing checks.
Right. They were writing checks. They were submitting forms indicating
What
that
form?
two forms. One was the tax exempt form indicating that they and not Inova was exempt from DC sales taxes,
Oh,
which was
okay.
what was required by the contract.
No, I understand that, but people again fill out all kinds of forms. And that doesn't make them a party or put someone on notice that they're a party to a contract.
The other form they submitted was a direct billing application, which identified them as the organization for the gala.
No, the contract identified Inova as the organization for the gala.
The contract did, but the submission of the direct billing statement identified Smith Center as the organization. That was submitted to Omni for purposes of conducting the gala. Omni's former catering manager testified that, of course, Smith Center was a beneficiary over the years, given their role in the proceeding and also the amounts of money they paid and the forms they submitted.
That may be persuasive argument you could make or not, but I hardly see how that compels a conclusion that they were a third-party beneficiary when they aren't named in the contract. The organization that is specifically identified as the organization for this gala benefit is Inova and not Smith. And someone else later sends in a check, fills out a credit check form because they're sending in the payments. But that was even just to send a payment not to Smith or Bill. Don't send the bill to Smith. Send the bill to Mr. Haswaka. That's not. I don't know that it would be unreasonable, irrational for a jury to say, sure, they were involved. It's a big gala. Lots of people are involved, but contractual beneficiary, that's a higher standard.
Well, in the Piedmont resolution case, the defendant argued essentially the same as Omni's arguing, which is they had no knowledge of the other party. And that case was even weaker than this case. The contract didn't name the third party, but there were wiring instructions that named the third party, which were related to performing the contract. And the court said that was enough to put the other side on notice that this third party had involvement in the transaction. Here, you have multiple years, year in and year out, of Smith Center paying both the deposit and the cost of the gala.
What might have happened in other years those were all independent contracts. We're just looking at this year and this contract.
Right. The prior year contracts were based on a template. All the contracts were the same, but for changes to the menu and pricing for that year. All the terms were identical, and they were all based on Omni's template.
Did you have evidence that Omni understood in those prior years that Smith was a third-party beneficiary
Yes,
and agreed to that?
yes.
No, you have the same evidence? What evidence do you have that Omni understood when it signed the contract that there was this third party?
The testimony of Dominic Sanchez, who
was
he was the former catering manager who was the initial contact with Mr. Hisioka.
catering managers execute contracts?
Yeah,
So he signed the contract?
he did, the initial one, 2013.
No, this contract.
No, by the time of the
He was long gone by the time of
he
this
was
contract?
gone. I'm not sure he was long gone, but
Okay.
he was gone.
He wasn't even around when this contract was signed.
No, I think he left 2 years earlier, but it's the same contract essentially.
I know, but it's hard to carry that knowledge forward when the person you say had it was gone for 2 years. It's not that, I understand your argument. I'm just trying to figure out the high standard for no rational jury could conclude.
All right, so that is our argument. We also argued that the district court's conclusion is bolstered by other surrounding circumstances. And it's undisputed that Inova, by entering into the gala contract as the promisee, intended to benefit Smith Center, who with Inova was a party to the fundraising agreement. That was the agreement where the parties agreed amongst themselves how to allocate the revenue from the gala.
Is that shared with Omni?
The fundraising agreement? No, but
And you just said agreed amongst themselves.
Right.
the beneficiaries,
Yes.
yes. So
We're trying to impute the knowledge over to Omni. That's what we're getting at.
no, understood. But as the court found in Safer versus Pepper, it's the intent of the promisee under the restatement that must be given predominant consideration. And this is called for by both the first restatement, section 133, the second restatement, section 302. Both restatements indicate that a beneficiary is an intended beneficiary if the circumstances show that the promisee intends to give the beneficiary the benefit of the promised performance. That's what happened here. So that's an additional factor that the court should consider in finding that Smith Center had standing, the intent of the promisee, Inova.
All right. Thank you, counsel. I think you're over time here. If you want to take up just a minute to sum up, that would be fine.
Sure. So it's our contention that the court did not err in finding that Smith Center had prudential standing and was entitled to summary judgment. There's no reason to remand the case on the mitigation of damages issue. There's no question that the breach was material. None of the material factors posed by Omni are satisfied. In addition, there are material factors that are ignored. Omni never suffered a forfeiture. There was no likelihood that Omni would cure its breach. The implied covenant claim was presented to the jury because it's an express term of the contract, and the jury was instructed on breach of contract, not breach of express contract. And no reasonable jury could find that Omni did not breach the covenant. Thank you.
Very much, counsel. Mr. Lemke, we'll give you 2 minutes.
On the question of the failure to mitigate and the taking that away from the jury, if you assume for the sake of argument that there was a material breach and you were turning to damages, the fact that there was a material breach meant that there wasn't going to be what they really wanted, which was the ambassador in the Regency ballroom. So they had to go to some alternate option. And they put on evidence that where they went at the Mandarin Oriental was not a good flow for the silent auction, et cetera. We should have been allowed to put on evidence to show that even if, in their view, the Blue Room and the Roberts Restaurant and the patio, the terrace were not as good as the ambassador in the Regency, they could have mitigated their damages by using them as opposed to going to the Mandarin Oriental.
So suppose after you told them you were kicking them out of what they contracted for, you were booting them out. Here's the other option we have for you. If they said, we're only a few months or 4 months away from the gala, I've got no choice. I guess I'll take it. Would that have been an accord and satisfaction?
Well, that's not the facts here, Your Honor. I haven't really.
I'm sorry. I'm asking you, of course, we ask questions all the time
Right.
that aren't the facts.
Right.
I want you to, you said,
Well,
I want an answer, yes or no. Would that have been an accord and satisfaction?
I don't think so, Your Honor.
Really?
Well, I mean, I think that, well, the question is, could they still say there was a breach and,
Not if they had said, choice do I have? I guess I'll take it. And had taken it. That sounds to me like a definition of accord and satisfaction.
well, Your Honor, then I'll agree with you. It may have been, but.
Okay, what case do you have that they have to accept the very breached terms? Like that's the problem for you.
No.
Is you don't want mitigation. What you wanted was accord and satisfaction.
No, I disagree, Your
You
Honor.
said if they'd accepted it, that's what it would have been.
Well, Your Honor, let me.
That's the difficulty with the argument you're presenting. I'm just trying to
All right.
present the difficulty with this argument is that you say, we breached knowingly, intentionally, someone paid us more, and so we're going to offer you this. And we know it's not as good because we're giving you enhancements.
But, yeah.
I'm going to finish my question here.
Yes,
We're
Your
giving you
Honor.
these enhancements. And your argument on mitigation is, and they had to take it. And of course, had they taken it, they'd have no case at all, as you just acknowledged, because when someone breaches and says, well, I'll sub this in, and you go, okay, I'll take that instead, that's an accord and satisfaction.
Your Honor, I think there's law out there that you can't basically extort them into taking something less than the contract. So, but here's the point. The breach was.
Your argument here is you think a jury could have done that.
No,
Maybe
no,
you
Your
couldn't have, but a jury could have said, you should have just taken it.
Your Honor, here's the difference. The breach was not having it in the ambassador in the Regency ballrooms. That's what was called for. That was the breach. Now, they then get to show their damages. And the question is, did they mitigate their damages? Not in accord and satisfaction to go to zero, but if they had said, well, we think this is breach and we don't agree with this, but okay, this is we'll suffer the least damages if we take the Blue Room and the patio and the Roberts Restaurant. Now, we should have been allowed to present evidence that that was a better option than the Mandarin Oriental.
Very difficult. Your position in this case is a really difficult one for contract law when things are offered that are so dissimilar, which was not the Sizer situation. So dissimilar. You recognize it. It's spread over 3 separate rooms and a tent, and it's very dissimilar. And so, but we think you had to take it. It was the best option for you. And yet, if I were their counsel, I would have said, if you just accept that, you've got to have no claim at all because they're going to argue accord and satisfaction, which you just agreed you could have at least.
Your Honor, they certainly could have reserved their contract right if they agreed to do it. They could have reserved their right of breach. But the key is, Your Honor, is
So they had reasonable choices.
That's right. I mean, that's the issue is once there's a breach and they're not.
Question whether yours was a reasonable choice, but that.
Yes. I mean, I think there is evidence, and I do hope you'll look at Joint Appendix 436 and 437, which was the affidavit of the general manager of the hotel talking about all of the high level VIP events that they had in these spaces. But
that's just utterly non-responsive. That's utterly non-responsive.
I understand
who's been there for a different event.
I understand your view on that, but
No, that's just not relevant to a jury. Different people wanting different things for different purposes doesn't speak to this situation at all. I wouldn't even let that before the jury. That's ridiculous.
all right, but that goes to breach. And once there's a material breach, then you have an obligation to mitigate your damages. They did not want to cancel the event, so they had to have it somewhere. And it may be, it's not that they would have no damages, it's just did they mitigate their damages? And there was sufficient evidence in the record to show that this would have been the better option.
So you're just trying to take what was it, $127,000 verdict down
Right.
to saying that.
The jury should have considered whether there was a better option.
Okay, but is it only monetary? Because again, you had a room that you're offering for character, for, specificity of certain things. And it's not just the difference in cost.
That goes to breach, Your Honor. I mean, but once you say, okay, there's a material breach, now we're moving on to damages, then we're into the different legal construct of mitigation. And the fact that it's not they weren't going to have what they really wanted at that point. And so they were coming up with a lesser option. And they came in and said the Mandarin Oriental was a lesser option. And what we should have been able to do is present evidence and said, well, you could have mitigated your damages if you had done these two. They might not have taken the damages to zero, but it would have been less. And we have the right, as in proving our affirmative defense, to put on that case. And the fact that we had breached, I think they're wrong on Sizer that there is no absolute prohibition under DC law that you don't have to deal with the breaching party again. And so
You have a case under DC law where they still have to deal with the breaching party when it was a bad faith breach and the counter offer was materially dissimilar.
I do not have a case like that, Your Honor, but I don't think that matters because the issue is.
Up here just real quick because we're over.
Yeah, the issue, Your Honor, is once the breach has been established, you have to mitigate your damages.
I understand that.
All right. Thank you, Your Honor.
Thank you very much to both counsel. The case is submitted.
Yes, yes.
Case number 25-5387. Friends of the Earth US and Justica Ambiental Appellants versus Export-Import Bank of the United States et al. Mr. Holtz for the appellants, Mr. Meister for the government appellees, Mr. Gar for the intervener for the defendant appellee.
Morning, Mr. Hertz.
Good morning, Your Honor. Good morning, Your Honors, and may it please the court. Richard Lawrence Herz on behalf of the plaintiff's appellants. I'd like to reserve 4 minutes for rebuttal. In March of 2025, Exim impermissibly approved a nearly $5 billion loan to subsidize a foreign company's liquefied natural gas project in a conflict zone in Mozambique. It did so without considering the environmental and economic harms in the United States or any complaints about the harms to local people, including from an ongoing insurgency and the fact that the guards that were guarding this project were implicated in a massacre.
But NEPA doesn't require an environmental impact statement in every situation. Is that correct?
The NEPA problem at the outset is simply that they did not explain at all the basis for their decision. And so there's nothing to review. The district court said, well, I'm giving deference to the district court's to NEPA's decision, but we don't know what NEPA's decision was. It's entirely unexplained. The district court found that plaintiffs made a strong showing that the refusal to grant the preliminary injunction would result in irreparable harm. But it resolved this case mostly on the fact that it made errors of law as to both standing and the merits. And so I'll start with standing and then move to the merits. The district court correctly found that plaintiffs had informational standing for their NEPA and economic provisions arguments. So I'll talk about the other theories.
In making those standing decisions, did the district court consider the PETA decision and the Alliance decision?
Yes. So what the district court did was it said that we satisfied PETA, but that essentially that PETA has been overruled by Alliance, and that's
But has it been overruled?
No, Your Honor, it has not.
Okay. Do they work in conjunction with each other?
Yeah, so let me turn to that. So PETA is a form of haven standing. Alliance explicitly recognized haven standing. Havens held that where the defendant impedes a core organizational activity, the organization has standing to challenge the impediment. Alliance agreed with that. PETA applied that principle. That's all it did. And it held that when an agency excludes an organization from a means of redress that's a core organizational activity, it has standing to challenge the impediment,
And
the
what's the
exclusion.
core organizational activity here? Because it sounds like you're suggesting objectionable conduct by the government and that you having to exert more resources, essentially.
Well, there's two sorts of buckets. On the PETA argument, the organizational activity is the ability to go to Exim and seek redress for the harms that the loan would cause. And so the Bank Act and Exim's own environmental and social standards require that the bank protects local people's rights, and to ensure that Exim meets its own standards, that its loans comply with its own standards. Exim can either impose conditions on the loan, or it can say, we're just not going to fund this loan because this loan cannot meet our standards. Section 10A of the Bank Act, the Notice and Comment provision, and Exim's notice due diligence procedures are the means by which People can come to Exum and say, look, this project is not going to comply with your standards and it's going to hurt, us and the people we work with. And so you need to apply your own standards. That is a means of.
Do you participate in the process?
I'm sorry.
At what point does your client participate in the process?
At Exum?
Mhm.
At that point, they would have gone to Exum and raised all these issues of environment, security, all the ways that this is going to harm local communities.
You're calling I just want to be clear, you're calling that an informational injury?
No, that is an exclusion from a means of redress.
Okay.
That is the means of redress. You get to go to Exum and say, this project will hurt us in all the following ways that are not consistent with your standards, and you should either impose conditions or not make the loan. That's a means of redress. And the district court agreed with us on that. That's why it said that PETA applies. But then it went on to say that Alliance had overturned PETA. And that's.
I guess I'm trying to understand this lack of redress argument. Which is they didn't do notice and comment. Right?
They didn't do the notice and comment in that in the 10A, and they didn't do a due diligence provision process, which also would have allowed the plaintiffs to come and say, like, look, these are the harms that this project is going to cause.
If I were, and obviously this is hypothetical questions to be clear to everybody, to be fair, but if I were really sympathetic to the work Friends of the Earth or Justicia Ambiental, I'm not going to say that.
Ja.
Sorry, with a nice accent. Really sympathetic to the important work they do caring for dispossessed individuals, people facing real hardship. And so I was donating money to both organizations regularly. And I wanted to participate in notice and comment if it were allowed to explain probably similar views to yours. And I wanted to participate in a due diligence opportunity for input to say, you shouldn't do this, you shouldn't do this, you shouldn't do this. Would I also have standing?
Probably not.
Why?
Because
it's an opportunity for redress for me, for issues I care deeply about and that I have put money behind. Why wouldn't I?
Because PETA has embedded in it a number of I would say probably requirements. So the organization, first of all, the process has to be a means of redress. The district court found that here. The specific harm has to be within.
That's true in my case. Notice and comment is still a means of redress.
Right. Right.
So we're even. Okay. We're both.
But then there's.
We both check that box. Okay.
Yeah. There's
box.
The next box is that the specific harm has to be within the organization's mission. Accessing.
So do organizations have different Article 3 standing than individuals?
No,
representation, but yes.
So if this were an individual,
just an injury to the organization, right? That's what you're asserting.
It is an organizational injury, yes. Just as in PETA, there was an organization.
Is it also an injury to me? And I can't do notice and comment.
So maybe I'm not. Maybe the hypothetical or that you're affording to that person isn't as broad as I expected. But if I could lay out what I think all the requirements are, and then I can see if it meets your.
Which ones I don't meet. Okay.
So the one that you might not meet is that you are
an organization.
Right.
Okay.
Well, if your hypothetical is if you were a person doing the exact same thing that the organization does, then yes.
But if I'm supporting and caring deeply about, I mean, I'm helping you to do it by giving you money.
Right. But for there to be an organizational injury, it has to be a core activity of something that actually engaging in the means of redress has to be a core activity, something that you do to promote your own mission. So it has to be both within your mission and it has to be something that you do to promote your mission. And if this person who just gives money isn't actually also doing the work of going to redress mechanisms, then it is not a core activity of theirs. So I think that's the distinction. But the point is that there are a number of.
Notice and comment is for the public. And Congress set those requirements for the public to participate in. And if I'm taking, money, I don't have much. I work for the government and I'm taking what I have and giving as much as I can and doing everything I can to support this work. Yeah, I can't be there on the ground, but I'm part of your team. I'm part of your, your people who donate to you are really part of your team and your mission. They're helping you do the work. You couldn't do it without funds.
So
That's not
they would absolutely have a right
to
participate in notice and comment. The question is,
But it wouldn't be
if
an Article 3 injury.
it might not be. I don't think the court has to decide that. What I'm trying to suggest is
I
that,
think we kind of do, because if we're deciding that the inability for some members of the public to participate in notice and comment is an Article 3 injury, we would have to say then it is for everybody, or we'd have to have a reason why it's not.
well, I think the reason that it might not be, and I don't think you have to rule on the hypothetical, but the reason that it might not be is that the way PETA frames this is it's an injury to a core activity. And so you have to be, the harms that you're trying to prevent have to be within your mission, and you have to be engaging in that core activity.
And
PETA says,
Part of my mission to support this work, again, this is all hypothetical, just to know, I don't actually donate.
oh, no.
Just to be clear. It is part of my mission. I'm not sure what it means to be a core activity. It's one of the biggest donations I make. We have to figure out what core activity means, or
Well, I don't think you have to figure that out, because I think PETA already answers that question. When PETA says that if you engage, if you engage in using this redress mechanism as part of your work to serve your mission. In other words, it's core to what you do, but it's an activity that's core to what you do. And the government just says, you can't do that. That's an injury to your work.
Maybe notice and comment is one of the core things you do. I had thought the core thing you do are services on the ground to environment or individuals. I would have thought that would be your core activity, not participating in notice and comment. Notice and comment would be a tool you use to advance that core activity. Is that right?
No, Your Honor, that's not correct. They do both. So they absolutely do direct services.
Define core activity.
Yeah, I'm not sure that PETA and Havens actually give a
What should
definition.
we do it if again, it's a really consequential decision for us to decide that notice and comment, an inability to participate in notice and comment rulemaking because it wasn't offered is an Article 3 injury, when notice and comment rulemaking across the government is something that's any interest. The test is whether you're an interested member of the public and want to participate.
If I can interrupt, this is Judge Randolph. It's not only a difficult position for you, counsel, but it seems to me it's inconsistent with the Supreme Court case, the United States versus Richardson, where the injury is common to all. The lack of information generated by notice and comment is common to everybody. And that's true under NEPA, and it's true under your argument here, I think. I don't know how you square that with United States versus Richardson.
Well, to start with your question, Judge Randolph, this particular argument is not about information. It's about the ability to participate.
Okay,
And
talk about
Well, it's the same thing.
Yeah,
No.
but, okay, so there's a loan that's authorized at the beginning. Where were you all? Were you at the table then on notice and comment?
we participated in the due diligence process in 2019.
Okay.
So there was two processes. We participated in the due diligence process.
But you're
in 2019.
challenging now the inability to participate a second time.
Yes, because everything has changed. There's been a war since then.
Well,
Since the first approval.
Counsel, can I ask you, the question of standing is not frozen in time. And you talk about things have changed, but things have changed as of today. The project is going forward. It restarted, and there's a new organization, the Mozambique LNG, that is helping 8,000 of these people in one of the poorest countries in the world, and it's generating 7,000 jobs. And so many of the arguments that you make were speculation, and it turns out that speculation's not accurate. So yes, things are not the same, but they're not the same today as they were when the extension was granted.
The only argument we're trying to make for this PETA claim is that we were entitled to raise these concerns and we were shut out of that process. And just to return to a question you asked me, Judge Millett, this is not notice and comment rulemaking. There's no rule being.
I get that. I'm talking, notice and comment happens across government in different forms. Sometimes it's rulemaking, sometimes they have to respond, sometimes they don't have to respond. But notice and comment is always, as far as I'm aware of, always opened up for any interested member of the public to weigh in.
I think that's fair, but I think the central point that I want to make about that is that if you're trying to determine whether this is a means of redress, as opposed to something else, like more generally like notice and comment rulemaking, you have to look at what they're actually doing through the process.
I think we've also held, I believe the Supreme Court too but certainly we've held that advocacy injuries, so don't count. The fact that you have to engage in additional advocacy doesn't create an injury. The fact that you want to engage in advocacy is not an injury under Article 3. Is the commenting you wish to do through this notice and comment process? Isn't it just a form of advocacy? You want to advocate for the people you serve consistent with the interests you advance?
So I think PETA answers that question too. PETA explicitly distinguished between denying access to an agency's means of redress and cases, on the other hand, that involve, quote, pure issue advocacy or a mere interest in a problem. And I think the court's bound by that holding.
Okay,
But
explain to me why this isn't, why what you would do in a notice and comment process, the input you would provide wouldn't be issue advocacy.
Well, PETA specifically says in footnote 4 that sure, you can comment, you can characterize all sorts of stuff as.
Just tell me why what you wanted to do here wasn't going to be issue advocacy.
Because what PETA says is when you are trying to participate in a means of redress, that is not issue advocacy. And you are excluded from. So I'm sorry.
I'm sorry. So you're here before this court seeking redress for your client. You are participating in a means of redress.
And if this court said I can't.
It sure also looks like advocacy to me. So I'm trying, and people participate in notice and comment proceedings all the time, and they advocate for what they wish the agency to do. And so I'm trying to understand. So I don't think the answer is going to be in PETA for you. I mean, if you think it is, please refer me to it. But I'm trying to get a practical answer from you for how the comments you wanted to provide to XM, that's usually what happens in this process. I assume there's comments you wanted to provide. Would not be you engaged in advocacy. It could be very good advocacy. That's not the issue, but it would be advocacy. I feel like that's what the notice and comment process is.
Well, so the holding of, I'll start with PETA and then I'll go to what we specifically want to do. The holding of PETA is that when you are seeking a means of redress, that is not the sort of through an agency process, and you are excluded from that. You have lost a concrete, you have suffered a concrete harm in a way that's different from just trying to generally promote broad policy.
Does it matter where we are in the process? So there's the initial loan, giving of the loan, and you mentioned that you all were there for that in 2019. But then we're talking about an extension time period now. So does that matter about whether the loan was given at all versus just an extension in terms of your arguments?
Well, I think it matters on the merits. I don't think it, I mean, that's sort of the fight on the merits. I don't think it matters for standing, because you have to take our view of the law, of the statute, for standing purposes. And we believe, I think the statute says that we were improperly excluded.
There's an extensive notice and comment process at the beginning. There's all this ability of the public, anybody else who wants to chime in, to deal with that. But then we're just talking about an extension here. And so why is there some real need to be there when the material terms of the loan, the project aren't different, the extenuating circumstances around everything potentially different, but the loan had been given.
Well, this is a merits argument, but let me just make it because I think it's how it answers your question. What the statute says is that the board, that there has to be notice and comment before any meeting of the board for final consideration of a long-term transaction. This went to the board for final consideration of a long-term transaction. That means there had to be notice and comment. So the statute on its face, by its clear terms, allows us, required Exim to have a notice and comment procedure. Our position on standing is that we have standing to raise that.
You said you already provided comments, at least on the due diligence process in 2019. You chose not to do notice and comment then. There was a change in ownership in 2020 and
Yes.
didn't participate on either grounds. You didn't argue for it there. Where in the record have you shown what you would have said for notice, had you been allowed to do notice here that you have not already conveyed to Exim?
Well, it's in the two job declarations and the faux declaration, but to summarize it briefly, one of the many things, the most obvious thing that we would have commented on is the fact that a war broke out. And, we would have.
Well, I believe everyone was aware of that. That's why, Exim was aware of that. They invoked force majeure. Again, I don't have a good French accent, but they invoked that. They stopped. That's the whole reason they have the extension. Export-Import Bank was fully aware that there were violent guerrilla activity in the area.
Sure, but they weren't on the ground because they couldn't go there. All their information came, as far as we know, from Total. What they didn't get.
But there's still, this insurgency had already broken out by 2019. Did you include information about it in your due diligence in 2019?
I'm not sure what we said about it in 2019, but the insurgency exploded in 2020. And that's when they declared force majeure. I'm sorry, 2021. And the massacre at the project's gates by Project Security was in 2021. And those are the sorts of things that, we would have raised. And they weren't getting that information from Total. The person that had, the only way they were going to get information about that, about seeking a means of redress and how to prevent these harms was from us. And, just to give an example of this, they said, Exim staff said it considered the security situation in 2025. We know for a fact that security plan that was existing in 2025 was inadequate. And the reason we know that is because 2 months later or 3 months later, Total scrapped it. They said this security plan isn't going to work. And the security plan that they adopted was one where they were going to make a perimeter, or they are going to make a perimeter that protects the project, but leaves local people outside the fence. And, everybody, all of the evidence in this record is that by restarting this project, you're making not just the project, but also neighboring communities an al-Shabaab target. Total's security plan is to throw their neighbors to the wolves. And, we would have commented about that sort of thing. And they're not going to hear that from Total.
Do you have more questions? No. Okay. There's no further questions from Judge Randolph, then I will give you some time for rebuttal.
Thank you. Thank you, Your Honor.
May it please the court, McKay Newmeister on behalf of the government. Plaintiffs here have not established a substantial likelihood of standing to enjoin the disbursement of loan funds during the pendency of this litigation for 3 reasons. First, there are allegations about the denial of an opportunity to submit comments in 2025 is a procedural injury in vacuo and pure issue advocacy that is not sufficient to support standing. They rely on the PETA case. That case is distinguishable on its own merits and is also if the theory of organizational standing underlying that case was eviscerated by the Supreme Court's decision in Alliance.
We have a pretty strict evisceration standard. And that they are irreconcilable. They can't be. And Alliance, on a similar theme, but it was much narrower than PETA. It didn't involve the same situation of where the USDA just was not engaging in the statutorily required activity at all. And so it was like a wall that the plaintiffs there couldn't get through to get them to do activities that would generate reports. You had information injury. It's very different than what was going on in Alliance for Hippocratic Medicine.
So I think the facts are different, Your Honor, but if you look at the organizational standing test that was applied in PETA, that was this circuit's test, and the test that the Supreme Court set forth in Alliance, those are fundamentally inconsistent. In Alliance, the Supreme Court said that it's not enough to divert resources in order to oppose government action consistent with an organization's mission. You actually have to show that there is a direct interference with core business activities. And the court made clear that there are two examples of what that looks like. One was how the court explained what happened in Havens. You have an organization that provides direct services. It is directly being given false information that is impairing its ability to provide those services. Those services are its core business activity, that is the kind of causal nexus and injury that's sufficient for organizational standing. The court also offered a second example in discussing this, and it said that if there's a manufacturer that is selling defective goods to a retailer, that's the kind of direct impairment of the retailer's business that can give rise to organizational standing. We have nothing like that in this case.
So imagine, this is clearly hypothetical, but imagine that as part of setting up this pipeline, that in order to protect themselves against Al-Shabaab, the company proposed to put landmines anywhere in a mile of the plant. That'll keep people away. And these organizations here are trying to take care of people suffering a lot within a mile of the plant. And now they're at risk of blowing up. Would that count? That sounds like pretty concrete interference with their on-the-ground activities.
I think that is a very strong argument and a very
strong.
That's not. I have no reason to think, putting aside causation, I have no reason to think that that's not the kind of injury that would be a direct impairment of the ability to provide services, because if they're independently engaging in these services, it's an independent core business activity that they're doing on their own apart from opposing government action.
Right.
And then if there's something that comes in and then prevents them from doing that is the kind of direct injury that is what the Supreme Court is talking about.
But they say here that, just to follow up, sorry, that what is coming in with this pipeline is an operation that is literally drawing targets on them and their clients' backs. And this is not fanciful, hypothetical. This is not speculative. People are already dying. Roads are already unusable, right? Hotel has to fly its people in. They have drawn targets on their back. I'm sure, not deliberately, but that's not really mattering for standing. And again, there's obviously disagreement on the merits on these things, but just for the purposes of standing, if we assume they're right, the approval of this pipeline has targets on its clients' back and anyone who's working in the area of this plant. Why isn't that sufficient direct interference with their on-the-ground operations for standing?
So that does sound like it could be interference if they cannot, if their ability to provide these services is interfered with, but it is not direct in the way that the Supreme Court discussed in Alliance. There, in discussing havens, you had an organization that was directly giving false information to the plaintiff that then they could not use to conduct their services because it was false and their services were then meaningless. When you have a manufacturer directly selling to a retailer, that's direct interference. What we're talking about with this insurgency theory of causation, it is an attenuated chain.
I don't know that it's that attenuated. I get your point. I mean, that certainly was going on in the Alliance for Hippocratic Medicine case, very attenuated. But here, the company itself recognizes the extraordinary risk occasioned by its very presence. That's why there's this fence going up. This is going to be an attractive target. And so we are putting up this fence, we're helicoptering our people in. So they're not intentionally drawing targets anyone back, but they are acutely aware of what their operations are doing. And I'm just asking for purposes of standing, why that's not a substantial risk occasioned by this activity.
So yes, Your Honor, if you look at the court's decision in Alliance, they sort of separate out two things. There can be a causal chain where there are multiple links that are too speculative. Your Honor's hypothetical posits that they're not actually speculative. But there's a difference between something being too speculative and too attenuated. Here, to be too attenuated means that you're actually, even if we think these links are likely to happen, you're so far down the road from the challenged government action that you can't say that that action is what is actually causing these results. And here we have allegations that XM approves the amendment. Because of that, the project can go forward. Because the project goes forward, it's going to create a target for this terrorist insurgency. Beyond the insurgency that's already operating in the region, it's going to increase those risks. And then as a result of that, you're going to have response from security forces, but we're assuming those forces are not going to be able to sufficiently respond to these risks. And at the end of the chain, because of all of that, it's going to be harder for these organizations to provide services on the ground, harder than it already is because of this terrorist insurgency in the region.
I mean, I understand your point about attenuation, but really it's sort of a but-for cause here. But for this fund, and maybe I'm wrong, but my understanding is but for these funds, no plant operating.
And I think but for causation is different than what the Supreme Court in Alliance was.
But for causation is pretty direct.
The direct relationship that the court was discussing in that case was there is a direct relationship between these two parties, the kind of relationship that gives rise to standing in private parties out in the world, not just challenges to government action. You have a retailer and a manufacturer, a direct interference with their business. You have an organization that uses this information, being given the information.
Give this person this money, I will be shot. You don't give this person money, there's less risk, I should say substantial risk I'll be shot. You don't give this money, that substantial risk reduces materially. Is that a direct cause?
So it's not, because it's not direct in the sense that we know that there are multiple independent actors in that causal chain that independently are.
You have someone who is essentially lights the fuse. If you light the fuse, knowing where that fuse is going, first it's going to blow up this area, and then it's going to next blow up where these people are working. Is that not direct?
So I don't think it is, Your Honor. And I think another way to think about what the problems are here is the causal link at the very end of this chain, that the organizations are saying that they need to be in the region providing these services and that they are basically being prevented from doing that. But the reason that they're doing that, they say, is because they tried to advocate against the project. They wanted to be able to advocate against the amendment and shut it down entirely. They couldn't do that. So as a result, they have to shift their resources to the region and then provide these services on the ground. They're saying they're forced to do that. They're only forced to do that because it's their mission to oppose this action. That's a voluntary choice that they're making to expend these resources to oppose government action. And they're saying that that is that's being harmed. Their ability to carry out their mission is being harmed in this way. And that's simply not the kind of organizational standing that the Supreme Court recognized in Alliance when it clarified this doctrine and the issues that had arisen in the doctrine in this space.
And what do you understand to be Friends of Earth's participation in 2019 in terms of the notice and comment period when the loan was actually extended initially?
So I know they didn't file comments in response to the actual notice and comment process under C10. They explained that they participated in the due diligence process. I think that's reflected in their brief that they submitted comments. I think the brief says that they were submitted in 2016. I'm not specifically aware of what other participation happened after that point. I also know that they have been in touch with EXIM sort of after the loan was approved in 2019 to express their concerns. The briefs reflect that there were various meetings, letters, a grievance filed, and they sort of have been participating, voicing their issues with this
And
project
you all
throughout.
have made the decision to not have a notice and comment period at the point of the extension. Why was that?
So no notice and comment was held as of the extension in 2025 because it's not required under the statute. When Congress set up
And you're saying that because your final approval of the agreement was back earlier.
Correct, Your Honor.
And you're considering the extension not a final agreement and not required then?
Yes, so C10 sets up a narrow notice and comment process that only applies when there is a transaction, high value transaction over $100 million that has to be decided by the board. And the board is going to act on the application for a final commitment, which is referring to the request for the transaction comes in the first instance and they decide, are we going to approve this transaction or not? But I think it's helpful to look at the actual process that takes place before EXIM. So there's that determination. Are you going to approve an application, sort of the overarching question? After that happens, then it goes down to the staff at EXIM and they have to put together the relevant financial documents and ultimately execute an agreement with the borrower. So now there's a loan contract in effect. That contract was executed, was operative and in effect, and was still in effect as of March 2025 when the amendment was approved by the board. So there was no new application, there was no new loan. There was an existing contract between the parties that the parties mutually agreed needed to be adjusted, and then the board had to vote on that to approve it because of the nature of its delegated authority. That does not make it the kind of new application that the process is contemplated for in C10. And it's important to recognize that these activities are expressly exempt from notice and comment rulemaking under the APA. And Congress decided not until 2012 to impose a narrow notice and comment requirement just for these high value, long-term loans.
Is that really your better defense as opposed to kind of jumping into standing, whether it's attenuated, if there's a causal link and what the intervening activities and everything are, that you just didn't have to provide notice and comment?
So we think we went on both, Your Honor. Standing is obviously jurisdictional. And so, there's a reason that we discuss it first. We think that the district court was correct, that plaintiffs simply don't have standing here on a majority of their theories. But if the court disagrees, then on the merits, we think that it's clear that there are narrow procedures that Congress wanted to impose so that EXIM could function like a bank and have the flexibility that it needed to engage in banking activities and to amend financial transactions that an ordinary financial institution would also feel the need to amend in the course of its business. Congress wanted a narrow notice and comment only to serve the objectives of the Bank Act. Once that was satisfied in 2019, there was no obligation to engage in additional procedures for this kind of amendment. The amendment was of only a 4-year change. If it had been 2 years, it could have been handled by staff without involving the board at all. It was 4 years because of this force majeure situation, but
a question about that. So
yes, sir.
what was happening was you have a brand new foreign company, not the original US, offering a brand new security plan for a materially new threat that had gotten so dangerous, they declared force majeure. why isn't that the type of material change that still requires the notice and comment under, I'm not going to get all the number right, 635A, you know where I'm
Yes,
talking about,
yes,
subsection
C10. Yes, so the material change provision in the statute only applies where there is an application that has been submitted, it's under consideration. The notice has already been published in the Federal Register, and then that application that hasn't been acted on yet has changed. And so at that point in time, if the changes.
This was definitely an application. It's an application to, it's by moving the dates. I mean, you can call it just moving the dates, but in fact, what it is saying we're shifting this whole contract forward into a totally new environment with a totally new company. Not totally new, that's unfair. A new and newly more dangerous environment with a new company that we presumably have not yet ever seen this type of security plan from. And you have a definition, I think it's maybe GA4, it might be the administrative record 410, but a definition of material change.
So the
That
material.
seems to definitely include, right, that it was, I guess it's a board resolution, the definition of material change.
A lot to unpack there, Your Honor, and I want to try to answer as much as is helpful to you. The definition of material change that's in the board resolution is not key to the meaning in the statute. What that means is that the board has the authority to do all of this business. It delegates that authority to staff for certain things. And
No, I get this means
Yes.
staff can't do it.
it means the staff can't do it, but it's material. There's a difference between what's material for the board to want to know about for an amendment to go forward and what Congress thought was material
Well,
for
why
notice and
wouldn't-
comment purposes.
I understand that, so I understand, right, this was not defined in the statutory term, but material change only has so many meanings. And the factors they have here seem to be exactly the types of risk to the government's investment of taxpayer money that Congress would have wanted to call material, so that these new conditions could be expected to substantially and adversely affect the ability of the borrower to pay their obligations. I don't know why that wouldn't be material under the statute. Going to affect whether they can even get an insurance policy. That seems pretty, if I'm a bank loaning money, that's pretty important.
So just
Security interests. I mean, it feels to me, I understand the procedural role of this resolution is not really a manual, but if this is going to substantially and adversely affect just one of these, the ability of this company to be able to pay back its loan, would that not also be material for purposes of the notice provision statute?
So no, because the notice and comment provision in the statute only applies under limited circumstances. All of the parties are in agreement that this material change provision in the statute only applies if there is a pending application that has been published but has not yet been finally decided upon.
Mm-hmm.
So the question is what we have here, an application under the entire meaning of C10?
Mm-hmm.
And the answer is no, because of how this provision lays out what kind of application is subject to this notice and comment process. So specifically, if you look at the language of the statute, and it's in, second, Your Honor, if it's in C10C Romanet 1, big I, the bank shall publish in the Federal Register a notice of the application proposing the transaction.
I think I might have lost that.
Sorry.
I might be in the wrong Romanet here.
It's under
C, right?
specific requirements under C.
Oh, yeah, under C.
In general, the bank shall, 1, publish in the Federal Register a notice of the application proposing the transaction. So that is the application that is driving this process. Is there an application proposing the transaction? That was the application that was filed back in 2015, seeking financing in the first place for this project.
By a different company at a different time when there wasn't this insurgency or terrorist threat. I mean, now you've got a totally different company. It's not even an American company. I think it's a French company.
But so I don't want to disagree if I'm misunderstanding, Your Honor, but I think the change in operator actually happened back in 2020 before this
No, I get
amendment.
but I'm
Yeah.
sorry, I didn't
Yeah.
put all my factors together. So, and again, they aren't challenging that. I mean, I would have thought maybe that would be a pretty material change
Yeah,
too, but.
they didn't,
I'm not
yes, they
saying-
didn't challenge anything that
But
happened in
instead you have a
2020 or
totally
2019.
new foreign company coming up with a security plan that didn't have to be formulated before. And so it seems to me that I get just the company switch itself is not an issue in this case, but putting that together with an entirely new security risk.
So
And it really is just sort of saying, moving the dates is saying, we're going to go forward with this loan and contractual arrangement, this new company, in an entirely different physical environment.
So in order to,
Bank anywhere wouldn't say that's a material change in circumstances.
so there's a difference between saying that that the change is something that the board would want to have the opportunity to consider, which is what the board did in 2015, is different from the question of whether Congress imposed mandatory notice and comment requirements for this kind of transaction, for this kind of amendment. And Congress simply didn't. Nothing in C10 applies to amendments to transactions that have already been approved, where there was an application and a final decision to issue a final commitment. In response to that application, there is a transaction.
So loan was already given, but
Yes.
you're challenging whether or not once already given, regardless of what other circumstances happen, you're just still relying on that initial application that was granted and that you're just moving the date on the extension.
Yeah.
And you would say, regardless of these material significant changes, that doesn't matter because the loan was granted?
It doesn't, because this notice and comment process only applies at the front when the board is making the decision, are we going to approve this application? Are we going to authorize this loan or not? Once the loan is in effect and there's an executed contract between the parties, that is operative. The parties were operating pursuant to that contract. There were obligations that were being met, and the credit commitment of $4.7 billion was committed. It was there, it was available, it was waiting for the circumstances to be satisfied, for that to be drawn down. It is still there, waiting for the circumstances to be proper, to be drawn down.
And
So you
would
have
always
this.
rely on the initial application grant process, that there's nothing that could ever change that based on extension?
There's not nothing. An extension of dates does not create a new transaction. There are.
I might be able to agree with you on that, but I'm
Yes.
asking also about a difference in circumstances, as Judge Millett is indicating too, whether it's the climate in which the extension is being granted, the reason that you had the force majeure in the first place, not just the movement of dates, because that does sound very ministerial.
Yes, it's the kind of amendment that's routine for a loan that the parties can mutually agree to engage in. And carrying out its bank activity it's a very standard kind of
Yeah, but the
amendment.
extension of dates
Yes.
is more ministerial. But
So
I'm asking
only-
about circumstances. Does
Yes,
that
Your Honor.
ever open up your comment period again? That's what we're getting at.
Only if an amendment is requested that Exim looks at and says, this is not an amendment to the application that we've already approved. This is not the same project that you're asking for funding for. This is something different. This needs to come in as a new application. So for instance, if this is a project for liquefied natural gas in Mozambique, if they submitted an amendment and said, actually, we want, a project for a coal extraction project in Tanzania or something. If there's a different country, if there's a different product at issue, then that's the kind of thing that's not an amendment to an existing loan within
Or
the
an
scope.
extension of a project that was already existing that for which you granted the loan application.
So if there's an expansion within the scope of sort of what was originally contemplated, then that's the kind of thing that a loan could be amended for, because the project itself hasn't changed. They've gotten approval for this transaction for the project that was within the application. If that's just within the scope of what the board already understood it to be approving, that's not a different application. It doesn't have to come in separately. I'll also just note that if the board were to approve something without notice and comment for $75 million, for instance, and then there was an amendment request that came in and said, actually, we want to up the credit that we're asking for, we want our credit commitment to now be $101 million. If it comes from underneath the notice and comment limit to above it, Exxon would look at that and say, okay, now you're actually asking for something that falls within C10. We can't just authorize that amendment. We need this to come in to go through this full process. But apart from circumstances like that, where it isn't actually a true amendment to an already approved application, this requirement doesn't apply. And that's because Congress wanted these narrow notice and comment requirements to ensure that it did not interfere with the bank's banking business.
Can I ask, I just have a fact question. Was the company given sort of a first disbursement of funds before it declared force majeure?
No, it wasn't.
No funds were dispersed.
They weren't. So in 2021, it was before force majeure was declared. It was determined that all of the sort of prior conditions that had to be satisfied in order to make the credit available to allow disbursement to start, that had all been satisfied.
It was a month before the force majeure.
Yes, Your Honor.
That's why I'm asking, because part of this is trying to figure out whether this is I'm gonna get the language, the final consideration. And if the money had not yet started running, and then you have this, I will use in a generic term, as a generic term, pretty material change in the environment and obviously the risks to this project before the money even starts to run. How do we, I get that this isn't their first application, but given some of the things you've said, well, if it's a different location, you said Tanzania is a different country or something, but if it was, if they had said, here's a place we plan to do it, and then in the intervening 4 years, that place floods, climate change or something, it's now flooding 3 times a year, serious flooding 3 times a year. But they never got any money, but now they've come up with a plan to deal with this serious flooding. That wouldn't count, that wouldn't trigger a new application either?
It wouldn't, Your Honor. So
Wow.
once the agreement has sort of been put
This
into
is a
effect.
wild bank here that doesn't, can't manage any other bank. I mean,
Well, so there's a difference.
Congress's design, you're dealing with. I get that.
It is. And there's a difference between something that the board wants to know about before approving an amendment. And, we have in the record that staff put together information that address these various considerations that plaintiffs are raising to present to the board so that they're aware of these things before it approves the amendment. There's a difference between that and the narrow circumstances that Congress thought the public needed the opportunity to comment. And if you look at in 2012, this is when this went into effect. And there is some legislative history in the record discussing why Congress wanted to impose this public notice requirement. And they explained that it's to ensure that the board has the information that it needs to make sure it's approving a transaction that's not going to hurt domestic industry. And there were concerns.
Speaking
Yes.
to that, when was it peaceful? Like, when did this conflict begin?
Before the initial approval in 2019.
So there were some circumstances of which you were aware that you were entering to the project.
Yes, and in the record, the memos reflect that this is something that Exxon was aware of before it entered into the loan in the first
And
place.
before it got approved.
Yes. And so but Congress wanted to make sure that the board had the benefit of comments so that it could decide whether this was not going to harm domestic industry. And in doing that, in the legislative history.
I thought it also had an obligation, though, to ensure wise use of the taxpayers' money. It's going to advance the interests of the people of the United States. Is that not also one of their requirements to consider?
In general, they're in the various objectives. I'm talking just specifically about the piece of legislative history about why they wanted the public
One
to
of their
understand
objectives
comments.
is wise use of taxpayer money. And they're now putting this money in a place that's going to flood 3 times a year and be inoperable.
And that's something that if it's an amendment that has to go to the board, that the board, is taking in a lot of information, is considering a lot of things about whether, there is a basis for continuing it or not.
They're only getting information from the applicant.
So as a formal matter.
Yeah, tell me. Yeah.
So as a formal matter, they get they get a request for an amendment, and then the staff sort of does a bunch of, work to put together and analyze various considerations. But there are processes for other individuals to submit letters, to have meetings.
Information.
Well, so it's not a formal process, but plaintiffs in this case had meetings with Exim, submitted letters, filed a grievance.
2025.
Not in 2025, but it was between 2019 and when the request for an amendment came in. So they're not
Did they post force majeure?
Yes, it was post force majeure that there were communications. So it's not the case that Exim is unaware of these considerations.
But that's actually helpful to know. But how are people supposed to know? I mean, they had reason to know because they were on the down. Their clients were getting killed. But how is the public supposed to know?
So Congress knows how to draft a statute that imposes additional requirements on amendments after an agency initially enters into this kind of financial commitment.
I get that.
They didn't do that here.
Maybe a more elementary question.
Yes.
When they file this application, is that a matter of public record? Can you go to the Exim website and see those things? Is that how you would know?
I believe you can track it all on the website. In the record, specifically with this application, it was filed in 2015, and then Exim posted it online, I believe in 2016, which is when they had the statement that they made the determination that it's not a major federal action for NEPA purposes, but they posted it online to make clear that they were considering this project and also linked to a social and environmental assessment with respect to the project. So it is public knowledge.
I'm talking about the application to move the dates. The one issue here.
I'm not aware if that is something that is specifically public, as a matter of it being released by
How are people going to
Exim.
know that they can send in letters to staff? I mean, it seems important to staff to hear what's actually going on the ground.
So I don't think there is a specific process for that, but Congress didn't impose one. And part of the reason is that it wants Exim to be able to operate competitively as an expert credit agency. And in the legislative history I was discussing earlier, it said that notice and comment is important so they have information about domestic industry. There were concerns raised about this actually delaying transactions. And the response was, we don't think this is this is just a short notice and comment period. And we expect that after that point, they're going to be able to sort of move forward quickly and put these transactions into effect. That concern about sort of the speed and flexibility with which the bank can act, just to be clear, there was 4 years of due diligence. This was a thorough process, but the ability to move forward once they know they want to approve a transaction is important. And the upshot of plaintiff's theory is essentially that every time a loan over $100 million needs to be amended in some way, that change is now the final consideration that has to go through notice and comment all over again. And that simply fundamentally cannot be what Congress intended in putting this together. And
You have a long time. I apologize. I just want to sum up in 1 minute here, unless Judge Randolph has questions then.
No, I'm fine.
thank you, Your Honor. So as a fundamental jurisdictional matter, plaintiffs have not demonstrated a substantial likelihood of standing. And regardless, the district court was correct that they did not demonstrate likelihood of success on the merits of any of their claims. And for these reasons, we ask this court to affirm.
Great. Thank you, counsel. Jagar?
Thank you, Judge Millett, and may it please the court. I think I'll begin with the standing question. As I heard my friend this morning begin on that issue, it seemed to me like he was making a classic means of redress argument of the type that I think the Supreme Court pretty squarely rejected in the Alliance decision. I think that quickly leads him to fall back on the PETA decision of this court. I do think that PETA, as the district court recognized, is questionable in light of the Supreme Court's decision in Alliance. I think this court and the Center for Biological Diversity has already essentially said PETA should be limited to its facts. And I think PETA is different here in meaningful respects. The claim in PETA, as I think Judge Millett, you mentioned earlier, was based squarely on the agency's decision not to regulate at all with respect to specific class of animals, birds, and to exercise authority that it allegedly had under the Animal Welfare Act. And this is not a case in which the claim is that the bank is not regulating at all. The claim here is that the bank has not engaged in a notice of comment process, a purely informational harm, procedural harm.
But what the agency's not doing isn't what decides standing, it's what the injury asserted was. And so, to the extent they're arguing that we, like PETA, as a result of this action, are not able, you're not treating this action as you should treat it. It's almost like you're not regulating birds at all or protecting them at all. In approving this type of material change, I think they said this was the longest extension they'd ever done. And it was dramatically new conditions with a new company. So just not doing any public input or notice could be well analogized to what was going on in PETA. Not as we need to, their injury is, we need you to be doing this regulating. This isn't just an extension motion.
Yeah, I mean, with respect, I would disagree. I mean, in PETA, it was the agency is not acting at all, period. It was an inaction claim. In this case, the agency has been acting. It obviously had notice and comment process.
I think their injury, they would have an Article 3 injury if XM didn't act at all here?
I think it'd be closer to PETA, Your Honor, and this court would have to reconcile with its own precedent. My only point here is that the PETA case is distinguishable, and I think that, this really should be guided by the heartland of the analysis and alliance. But here, their claim is not, really, when you look at it, it's the failure to engage in notice and comment that they say was owed under the Bank Act. And it wasn't, and I'd like to get to that merits question. But it's not.
I would assume the answer to the notice and comment question would be the same if they hadn't acted at all. And you should have acted like the Department of Agriculture. And had you regulated, you would have done this notice and comment thing. I would have thought you'd still have the same issues under Article 3 with the notice and comment.
I think it's distinguishable in terms of what was going on, because here you have an agency that is regulating. It has engaged in notice and comment with respect to the long-term financial transaction that is at issue. And in fact, it continued to receive comments and input on the transaction even after the amendment was proposed. I mean, the bank actually engaged in a separate memorandum, and that's available at JA 719 to 62, in which they continue to analyze this issue with additional inputs. It didn't engage in the statutory notice and comment process because it wasn't required under the statute. And just to sort of, flip forward to that, my friend walked through the statutory terms, but I think they're very important. I mean, the statute requires notice and comment with respect to final consideration of a long-term transaction. That's in 635A C10A. But then it goes on to set forth the specific requirements, and that's in C10C. And it says, published in the Federal Register a notice of the application proposing the transaction. The transaction is the loan that funded this project. The fact is that Congress didn't establish, it might have, but it didn't establish a separate notice and comment process for every amendment. The transaction itself, the loan itself, the terms of that do cover amendments. But the statute, Congress didn't require the bank to engage in a separate notice and comment period for every proposed amendment or any amendment. And that makes sense because
material changes.
With respect to the application on material change, Your Honor, what it says is material change as to the application for a loan or guarantee. That's in D Romanet 2. So
since the money had never actually started running to them, then how do we know that this was not, had it been running and then had to stop? I think you definitely would have finality, but if they hadn't cut a check or whatever, transferred money to them, how do we know it wasn't still at a point where it wasn't finalized? Usually that's how you know your loan.
Well, that we know
finalized is you get the money, and they hadn't gotten the money yet.
Right. We know that the application was for the loan, and we know that was considered and finally approved by the bank.
Well, they said
And-
a month before the force majeure, okay, now we're ready. Please give us the loan. And it never happened. So I'm just wondering, it seems to me there's some complexities with, at least just on the facts of this case. I understand the point about applications, but the status of this one is a little less clear if they hadn't actually completed it, but which is, I think, how you complete a loan is giving folks the money, and they hadn't done that yet.
Well, I think that's not at all the way the statute is drafted. I mean, the statute is drafted in terms of the application, consideration of the application for the loan. That was considered,
For the
it was approved.
final transaction.
It says final.
And if sorry, I'm trying to do the math in my head here. So if in 2020, and they're still going through the process of getting final approvals and everything, get themselves set up to be in a position to start receiving the monies and actually, I don't know if you have to be ready to run the project when you get it, but whatever it was that caused them to wait until March of 21 to say, okay, now we're ready. Now we'll take the loan. If it had been much earlier, would we still consider it final? I mean, how do we know when the application process is being finalized? Has been finalized, the final action has been. It's not when the money's sent?
So the question under the statute is final consideration of a long-term transaction.
Mm-hmm.
And we know that the agency gave final consideration to that transaction when it approved it in connection with the notice and comment that it gave. I mean, I think you're talking about is when did the loan somehow become operative? It was operative when it was approved, and there was a number of conditions. Like any complex financial instrument, there are a number of various provisions in there. And one of the triggers in terms of the timing was affected by the delay, and they simply amended that loan to extend the financing period. All, by the way, during the period which was considered when the board approved the loan
The
transaction.
conditions precedent to disbursement of funds are not precedent to final action.
Not before the board. I mean, you have an application which proposes the transaction. That's considered. There's notice and comment with respect to that. The board approved that. And then there was a subsequent amendment. The amendment provision, which is in Section D, refers to material change with respect to an application for a loan or guarantee. The application had already been approved. And again, when you think about the way banks operate and loans have to work, there are many amendments to loans. And if you had a
I'm not
provision.
talking about a limit. I'm talking about what are the conditions precedent to getting this money? I assume those are part of the proposed contract.
And it was those conditions precedent were approved by the bank.
I know, but they weren't met yet. Imagine they'd never met them. Your position would be they still had taken final action on this transaction.
The final consideration of a long-term
transaction.
transaction, sure. I mean, the bank considered it and approved it. I mean, we're talking about things that happened and this is why the terms of the loan were amended, but the application itself, which is the central document under the statutory scheme, was presented to the board, considered by the board, and finally approved. And again, Congress could have written a statute differently that required.
So, do you equate final considerations with final approval?
I think the final consideration is part of the final approval. And I think it refers to the transaction, which, as the statute makes clear when it's talking about the specific requirements, is the notice you have to publish in the Federal Register, a notice of the application proposing the transaction.
Final approval happens before the conditions precedent are met.
The conditions precedent are in the document.
I understand those are in the agreement term. I'm saying final approval happens before the conditions precedent are met.
Yes, they certainly can, because you have an instrument that's looking forward. I think that they, typically you would have an instrument with various conditions precedent, and that is what the agency is considering it approves. And then you go forward as you would in any other commercial transaction. Whether there's a delay for one reason or the other, and you have to go back and look at it, you could amend it. But the statutory question is whether amendments have to be run through the notice and comment process. Here, the notice and comment and the various processes that took place took years. So if you had a regime in which every amendment required this to go through the process again, nothing would ever get proved, nothing would ever get done. If I could just circle back to the standing question now, I think they are making basically the same argument as their central argument that the Supreme Court rejected in Alliance, that because they're unable to participate in this process with the agency, that they're going to have to expend additional money in getting the information out, and that is a harm. And I think that does not work. And I think—
But you don't dispute there's informational standing under NEPA. I understand you dispute the merits of the NEPA claim, but they definitely have standing for the informational requests for NEPA.
I don't think that the informational request on its own, I think they have to connect it. And this, I think, gets back to what the Supreme Court said in Alliance. They have to—
No, you don't. I mean, when you have a statutory right to information, it's like FOIA. We don't require people to show yet another injury behind that. If Congress says you have a right to information and you're not given it, that is an Article 3 injury.
Yeah, I think
we're going to revolutionize FOIA law.
Well, I think in Foundation for Economic Trends versus Ling, what the court said was it had never sustained an organization standing in a NEPA case solely on the basis of informational injury. And here, by the way, they did—
Has it rejected it?
I haven't gone back and looked at all cases from that perspective. I think it's—
What NEPA is government give us information. FOIA is government give us information. What injury does someone need in a FOIA case other than I had a statutory right for information, I asked for it and I didn't get it? Do you agree that still gives you Article 3 standing in a FOIA case?
I don't think the informational harm alleged—
Do you agree that gives you Article 3 standing?
No, I don't.
In a FOIA case.
I think you'd have to show something more than just the informational harm. I mean, FOIA may be different, Your Honor, but
I don't know how we draw this line. How do we know NEPA is an informational, agency? You're supposed to have this information. And FOIA is agency, you're supposed to give it to us. But we don't require that they have, and I need that information because it will help me write my book. We don't require that in FOIA. And so I'm trying to understand under what rationale you believe that we could require more than the informational statutory argument that I'm entitled to this information by law Congress has passed, other than I've asked for it.
Yeah, I think if that's the case, then it would greatly expanding in the environmental context, because anyone could come in and say, well, I want additional information.
Well,
and
it has to be NEPA. NEPA's, again, not to get to the merits, we assume they're right on the merits that a NEPA analysis should have been done here. I'm not deciding the merits of that, but we assume that for standing. And if they were right and it had to be done, they were entitled to see that information. That's all they have to do for an informational injury. A lot of people got mentioned didn't touch informational injury.
Right. I think that would be inconsistent with Foundation for Economic Trends. I think, just to leap ahead to the merits, where the court said the informational injury under NEPA in itself wouldn't confer organizational standing. But I think just to jump ahead to the merits, there's clearly no right to information under NEPA here. There was not a major federal action here, and the agency actually found that. And you can look at JA 184. Moreover, NEPA's extraterritoriality exception would clearly apply here. We're talking about a project that's halfway around the world. And so I don't think there's any basis for them to claim a statutory right to information under NEPA. And so I think—
I said we assume the merits.
No, right.
I was just responding to your standing argument.
Right. So I think that, if you disagree with me on standing, then I think on the merits, they've got no statutory right to additional information under NEPA. NEPA clearly doesn't apply. It's not a major federal action, and it's it's an action that is not taking place within the jurisdiction of the United States. The last thing I would just say on standing, Your Honor, is I think that they are ultimately all about issue advocacy. You can look at their missions, and what their mission is to educate people against climate change. To the extent that they're involved with helping people on the ground, I think the problem that they have here is that they have to rely on an attenuated, indirect impact, which distinguishes this case from Havens and other cases. In Havens,
Yeah, I think we've heard about that already.
Okay.
If you want to wrap up real quick, then.
No, I would urge this court to affirm the district court's decision. They have to show, we've been debating these issues, they have to show a substantial likelihood of standing and a likelihood of success on the merits. Even if these are borderline calls, I don't think they've met the requirements for the extraordinary remedy of a preliminary injunction.
All right, thank you very
Thank you,
much.
Your Honors.
Okay. Mr. Hurst, we'll give you 2 minutes.
Thank you, Your Honor. So just a quick note about each of our two standing theories that we've been discussing. Well, I guess there's a third now, but I'll stick to services and PETA, and then a quick note on the merits. We are in exactly the same position as the plaintiffs in PETA. We are using an agency mechanism to protect people the same way in PETA they were using an organizational agency means of redress to protect birds. We have a concrete interest in that, in the outcome of the process. We've been trying to protect these particular communities for years. Had plaintiffs but not been locked out of this process, they could have made changes to the project that would have avoided the harms that are within plaintiffs' mission to protect. That's all PETA requires.
Were you locked out like PETA, or you could have sent in a letter?
Well, sugar growers is clear that that informal procedures don't take the place of formal procedures. And the reason for that is obvious here, because comments have to go to the board, but letters can go in the trash. So there's a reason why there's a formal procedure, and those procedures go to the board, and it's the board made a decision.
Have you been sending in letters in the past?
We have contacted informal. We have contacted Exum in the past, but again, the benefit of comment under 10A is that those comments go to the board, and the board is who is ultimately making this decision. Why don't I get to that just really briefly? The important on the merits, the reason that this was a final consideration is because it went to the board. My friend said, oh, there was this loan that was, it was operative. That's their vibe was all they were doing was changing amendments. That's not true at all. There was no loan if the board didn't approve it in 2025. The board could have said no. That's undisputed. And I heard a lot about conditions precedent. Exum changed the conditions precedent in this for 2025 to include a bunch of security conditions precedent because of the insurgency. And that's at JA 750 to 759. So the provision about when notice is required is crystal clear. It's required when the board considers a transaction. The board considered a transaction here. They try to replace the word transaction with application. They try and replace it with amendment. But what the statute said is transaction, and this went to the board by their own rule, because even just the dates, an extension of 2 years could have been done by staff. That wouldn't have gone to the board. An extension of 4 years has to go to the board.
Right. Okay. If there's no further questions from Dr. Judge Childs. Thank you to all counsel for your advocacy. The case is submitted.
Thank you, Your Honor.
This honorable court is very much the